free-flowing conversation.
Uh,
Good afternoon. Welcome to the meeting for the Ad-Hoc Outside Council Committee. We are here because we want to discuss just generally the next steps for outside counsel Mark Wallach's engagement on the records issue. So I've already sent some of the records kind of documents to Mr. Wallach, but he would like a little bit more direction on that. So I thought we'd just have an open discussion and conclude with an email that can be sent to Mr. Wallach. So this is of enormous kind of immediate importance because we generally have most of our important disciplinary records still outstanding. So I didn't know if other context is needed. Do we have any more thoughts about this?
So we're basically asking, we want to get the outside counsel's opinion about our powers to get the records or what the right approach is. What is it exactly we're asking him for?
Well, I thought because our records requests are right now being handled with the DOJ's kind of and the monitor's advocacy in the federal court. The charter, if you notice in the consent decree conferences, that Judge Oliver never mentioned state or local law, but the charter is, a local law. Eventually, the charter has distinct authority on records requests, distinct from Judge Oliver's ruling, which is 21 days, but our charter authority is no redaction and basically immediately, or as reasonable amount of time. So we probably just need to know what the next steps are. I would like to see, personally, Mr. Wallach issue an opinion as to what, after reading the documents, what our rights are under the charter, how best to leverage that, because we do have pending records requests, and this, no matter the intent, all we know is that that we can go into a year after the fact and we still don't have some of these records, and that's not a workable situation for the other parts of the work that we have to do for the commission to go forward.
Right, so,
Yeah, and so I'll just, Commissioner Wong, you remember when you and I first talked about this and why it's important? I think it was in when you were discussing the disciplinary records in the Brady Giglio work group. And we knew at that time we needed an outside counsel because, to your point, the charter does not give another city department the ability to object to a records request. However, the federal court has allowed that under the consent decree, right? So we're dealing with two parallel tracks here. One, to your point, the local, which we don't have representation on because that's why you declared conflict of interest. We do not have an attorney that can take this to a local court should the city decide to not provide us a record. So we do need to define what happens if the consent decree isn't here. Take that out. It's not disrespecting Judge Oliver and his system or the federal court in any way, but this is at the end of the day a local issue. And Charter 115.5, it is not decided what happens if the city does not comply with a records request. So you need to know clearly what your options are provided that situation were to occur, and it is occurring. So it may be for the time period the best interest of the commission is to defer to the federal court until such time the consent decree doesn't exist. But that time will come, and you will need to understand what your true power is. So it is time to answer that question, and then we can write rules and procedures around a good legal opinion on what our powers actually are under the charter and what our recourse is if we are denied under the charter.
So Mr. Wallach can probably explain to us the recourse is in state, there's a court that you can sue for it, but my understanding is really to determine whether something is a public record. I would very much like him to answer the question whether what we need to do to invoke that authority, right? Whatever that authority is. Is it like a majority motion? And I think it's just not a workable situation right now. We have the requests from the discipline, from accountability, and that went for the departures from the last 2 years without body cam. So without really that much need for redaction, that was made in July. So we're almost happening upon July now. So waiting for the federal court, I feel like we're just constantly waiting, and I'm not in these meetings that they're having every, is ultimately we're gonna, just to the point is that we might as well have, if we have powers under the charter, we might as well try to invoke them. We still don't have the record for the Tolbrook case either, so.
So my question goes back again, it's like what we're asking him, the basic question is what are our powers under the charter? And that's the basic one, right? It's like some outside legal opinion says, here's what the charter says from this perspective. That's the basic, the first and foremost question. And after that, we got to figure out how do we use those.
Yeah.
And is that his role to give us opinion? Like, here's what you can do. He can't tell us what we should do unless we're asking him, like, tell us what to do. But we're asking him what our options are. Those two questions: what are our powers as he reads them, and what are our options to use those powers?
I think
Is that it?
I think there's something more here too. Is the city frequently, although they say they recognize that we are not making public records requests, there's still a lot of confusion over that, right? And they often use objections that they would use for a public records request. So another thing I would seek is clarity on how we're different from a public records request, right? So if the city is treating us as a public records request on some of its current objections in the federal court, it's too voluminous or it needs to be redacted. So there's some issues there that I've seen even before this commission was seated, and confusion about what type of request we were making under the law. And so you need something firmly from an attorney that says, possibly says, because I'm opining here, that your request should not ever be treated as a public records request. Because the other bizarre part of this is, let's say we were to use subpoenas. How do you subpoena yourselves, right? So how would you issue an inter-city subpoena when you are a city department? So those questions come up in other places. So it may be good to look at in the scope of this, how places do that otherwhere, if they're in other places, if there is case law and precedent on investigatory agencies such as inspectors general offices or other quasi-independent entities where they have to have gone to court to fight to get records from themselves, so to speak. I think those are things you want to ask for too, is are there precedents and legal precedents in Ohio or in other places dealing with investigating yourself, so to speak, and obtaining records from yourself when it's adversarial in that way. So
that was the point I wanted to make, that I think it was the last consent decree conference. Delonte, I think Spencer Thomas said, and I don't want to misquote him, but I believe it was that he was saying that that our records request process was distinct from the public records. However, what I've personally witnessed, I don't see how it's distinct, because we are having to wait for redactions. We are, when I do a records request to Ms. Huff, rather than the division, she does an actual public records for me. So for the city also to better articulate how we are actually even different, because I don't see any enormous difference at this point, to Jason's point. And then a lot of the resistance is like, and there's lots of, from the emails, maybe it would benefit for me to actually put all the emails out there that I've had dealt with these records requests. They make a lot of arguments that are basically about public records, So.
There is another big point that you should consider asking Mr. Wallach's opinion on, and that is this: are you a law enforcement entity under Leeds, right?
Yeah.
Because you have control over so much here, and the idea that you don't have some role in law enforcement. So you're talking about, do you make the final operational decisions? You set policy, you set training, right? So what are you, right, under the law? Because they're denying certain things based on Leeds law. So you also need him to look in an expert way at that opinion that the city cited from the state of Ohio, because the DOJ and the monitoring team have made wonderful arguments, but again, they're using broader context. They don't have local government experience. So I would also give him that opinion and ask him to see if there's an alternative way in the state to get direct access to records, because I think that's the way most places do it. So you may want to consider asking him, is there a legal justification for direct access to some of these systems, like the records management system they use, the CAD system, so that we can see in it with certain restrictions without having to ask for records, right? So does our power grant us authority to see records directly without having to go through this requesting process? That's another question you may want to consider asking.
So do you think, so I've sent all these documents quite a while ago. Do you think that that represented all the documents, and maybe, I think we have generally the questions, maybe if all the members of this group can just reread those. Do we remember like the general arguments that they've made? There's the leads argument, there is that's the primary one, there's the volume argument, right? And
The
there's
redaction.
the redaction argument. There was also briefly like a public records argument, to do it as that. And so maybe we can map out the arguments, attach them to and then just ask him his opinion on the validity of these arguments, and also what the recourses are, and what we have under, and this is like kind of an immediate thing, like with a lot of other things, do you have any timeline with the federal government? We have, what is the status of the Brady Gillia request and Tolbert's request and the discipline request? Like we got some partial records. I looked at them. But my gosh, it's like, these other forms, so that record request was from October, right? So we got some in February that were redundant, that were the divisional notices. And now we just got some incident reports, which I can show you. They were just summaries of what happened. And it seems to be, especially, it was concerning to me because it came from IA Pro. So how much time? I always question the volume issue, because these are many times electronic records. Obviously, it's not like a photocopying type of limit. So I just think that we just get him. He just wanted a little bit more direction on it, so we can probably frame those questions. Mr. Van Leer?
Did you have anything? You haven't spoken yet.
No, I think Commander Carney made the point that everything is digital now, so we should have it. I got a quick question for Jason. Do you keep a log? We make a public records request or that kind of case. Is it under a case file? How are you organizing that? So if we had to present this sometime,
We have our own tracker, and now there's been a master tracker created, which the DOJ, the monitor, and us are all involved in. That is a little more detailed because it involves all the parties. But yes, they are tracked, and there's and it tries to keep a response time ticker on there and all of those things.
So how often would you send them a reminder? You know what I mean?
Well, so that's the thing. You don't. The idea of reminders, so they're aware of every request. So I'm not of the idea that you have to keep reminding them. They're aware. And not only that, it's on the court record. So either they've objected or they haven't. At this point, even their objections are moving backwards, where they're producing things they originally objected to. I think ultimately, I will say we're going to get all those records. But the question of if they are to do this in the future, we got to look beyond us, right? Right now, they know, I think they're aware that the court is going to order production of all of these, right? So these objections, the best they got out of them was an increase in time, but everything is coming our way. So far, even the ones that they asked for the longest time for, they've said, you know what, we're going to start providing them, and they have. So the issue here is, though, beyond us and beyond the consent decree, what happens when the next group of people sit down and have to redo this whole conversation, right? We should be thinking long-term, to Commissioner Wong's point, about what are our true powers and how do we address this, instead of just micromanaging this process to exhaustion and starting over with a mother may I. I don't believe 115.5 puts us on a asking, right now it's the style of asking your parents, can I have something? I don't believe that's the true spirit of 115.5. It's not an ask. So it's being treated like an ask. The other thing I've said is this became, in 2021, this is when it passed, right? You can anticipate looking, if you're just a business planner at any organization, right? You can anticipate that we were going to do great deal of records requests with all the powers that we have, right? So who has the burden, and this might be a question, where is the burden on meeting these requests, right? If the charter says they must produce documents, and we know that it's gonna be voluminous, does that mandate that the division in city law have to staff up to be able to handle this request? That's how most cities handle this. So we are in a place where it's a exhaustive process because they're making it that way. It's solved simply by, if you want us to make requests and asks, then you must staff up to accommodate those. Or in the alternative, other places who do this have direct access, so you're not on the request and ask process, right? So we're approaching this from a very stressful and conflictual place to begin with, where other cities have already worked this out and they're moving it forward. So.
Thank you.
So, yeah, so the four things then are, what are our powers under 150? This is what we're asking Mr. Waller. What are our options to use those powers? What's the best way to use those powers, or what are,
How do we, yeah.
how do we use them? Might be more than one way that he might recommend. And then the public records versus subpoena versus, like, how would a subpoena work? What does that all mean? And then access to the systems directly, like leads or whatever.
I think we also,
Those are the four questions, or is there?
yeah, I think there's a few more. I think we need to ask him what our options are if there's more resistance from a legal perspective in common pleas. I also would like to know the best practices to facilitate, right? It's for even words like rolling production. Like, what I would like to know, maybe if we could do a catalog of the records that exist, maybe, that will help us be more precise in asking for particular records. We don't even know what type of documentation is there. So do we have the ability to ask for, like it's a library, right? We're supposed to go in and say, we want this record. How do we ask for it and get some type of how do we get that shared vocabulary so that there's no
Access.
Yeah.
So that's what
but that requires access. for us to look at the
so
system.
let's use IA Pro as an example, right? It's already partitioned off for level of access, right? So they're giving you incident summaries right now. There's no reason with that level of technology we couldn't have a login to IA Pro where you can only see cases that have incident summaries, right? So you're partitioned off by the software at your level of user that says we can only see these records or run these queries, right? So instead of asking for those, and right now the argument is there's 550 or something like that incident summaries that they have to provide for us. Instead, we can log into a system and search 550 documents that are walled off for us to be able to see. You can't tell me in this day and age that that isn't possible, right? So I think our larger fight here is the question of legal access. What power does 115.5 have to give us legal access to systems and databases? To your point, to have an index of everything you can search is exhaustive too, because it's always changing. Why not just have access to that same program at a researcher's level, walled off, where you can't see restricted law enforcement information? They do it all the time across the United States. So I think that's a big question here for the attorney, is what legal right to access do we have, under 115.5?
So I think that's basically everything.
Yeah, and my only question was, so I have 5 things now, before I mentioned before, the best practices piece. But then there's one thing you mentioned about how we get past resistance, but I feel like his other answers to other questions should deal with that.
Well, I mean, I think he needs to map out the actual legal track. Like this, if we have to sue, he needs to tell us what to do there.
Okay.
This
I'm
is
just trying to,
have,
I'm writing it down so that.
Right, so I know we're always relying on pizza. But that could be that, because there is, I would like to know what the law says, because we know what generally law says about public records, so what does it say here? And certainly we should be given it as much as what public records are given, right, in terms of state law. But we just never heard any comment from Judge Oliver. He can't invoke, I guess, local and state law.
No,
That's his thing.
you couldn't. But that's the thing. I think the only equivalent is you could think of it as the same thing. An auditor and inspector general would have these powers, right, if they were associated with that same unit of government, to have access to request records. So I think there are parallels out there, even though maybe not specifically dealing with civilian law enforcement in Ohio. There are places that have associated auditors or entities that are part of them, but have independence and can ask for records internally, and those places must comply. So there are parallels that we can look to for precedent here. So,
Okay, so then we'll just gather that, write him a letter, make sure that those documents are, I still have to attach the emails that I sent. Do you have any emails that you sent on records that weren't fulfilled or had any argument given? Just, I think we're looking for anything that has any argument given by the city for their authority. So then we'll just gather them. We've already approved 6 hours, so it should be enough time. And then ask him to write an opinion and then come in to present it, right? To the rest of the commission or send it to us. Does that sound okay? All right. All right. Anything else that we need to do?
Who's gonna draft a letter? You want to draft a letter?
I'll draft a letter. There is one other issue, because Martin and I have been talking about this. There has been, even community members have said that because Martin is in conflict on the records, what does that mean? Does it mean that he's only in conflict on the records request or anything having to do with records? I'd like Mr. Wald maybe to answer that. He's expressed the same concern that it's too close. Some of our processes, Mr. Wald, that some of the processes included in our processes involve records requests. So where does Martin end, in his conflict? But these are things that he could probably just find. That there is, and I think we would like him to probably map out a procedure for us, right? What the actual concrete next steps are for these records requests. So we'll have to give him the tracker, everything else. Okay, is that anything else?
I'm good.
Just wanted to touch base with, he generally understood what to do, but we wanted, so if you want to send the notes, everybody can
I
draft a
will
letter.
do that. I'm looking right now.
okay. You want to give, see if Lou wants to come
Lou,
in?
do you have any public comment? Yep. That's the shortest meeting ever.
Well, I'm glad that we have this kind of meeting to get all our questions organized, because it doesn't matter it's in-house counsel or outside counsel. I mean, they're expensive to a certain degree. So getting our questions organized, that actually will help us to save some money, and plus that would give the confidence to the outside counsel that you are capable of some critical analytical thinking, so later when he comes up with a good ideas for you guys to adapt, at least what to go for. And this will be a very good way for all the commissioner to do homeworks right now. Otherwise, even the outside counsel, doesn't matter who that could be, offering a good plan, and most of the commissioner probably will have a hard time to comprehend. So I really appreciate having this meeting. Thank you very much.
One other thing I had, Jason, where are we in requesting the transcripts from the actual consent decree? Because there's arguments made in there.
The consent decree transcripts?
Yeah.
We should be able to get them out of Pacer, so Martin should be able to just pull those.
The transcripts of the proceedings?
Yeah, they're usually entered into the journal, maybe. I don't know, I'll have to look and
You
see.
might have to order them.
Yeah,
So
yeah.
can we,
Yeah,
because I
we'll look and
requested
see.
that.
Yeah.
And can we make sure every Pacer document is there for Mr. Wallach so we can?
Yeah, what, the motions? Yes. We have the motions
Why
that related to this, so we could forward them.
Okay.
Yeah.
Why don't we start a folder for this? And then I'll author the letter and I have the 6 review.
Every motion that's come, I forwarded to the entire commission, so you should have them all. So every time that there's a motion in the consent decree, Martin pulls it, and it should start with activity in case with the case number. So if you search those key terms, just activity in case, you'll see every single motion. But if you're missing one, go ahead and I'll
I'll just put them in a folder so we have them because it's like a long-term project for us too. So, all right. We all set? Anything else, Dr. Adams? Okay. Thank you so much. Appreciate those who are tuning in.
Adjourn.
Adjourned.